Are you okay going without Mr. Bowditch? Come on up. Pretty simple. Up to $500 fines plus court costs and up to 93 days in jail.
Understood.
Okay. And you understand if you plead no contest, what you're saying to me is you're not fighting the charge against you.
Correct.
All right. And if I find a factual basis that supports a guilty plea, from that point forward, I'm going to go as if the file was a guilty plea, there'll be a sentencing. You understand all that?
Understood.
Good morning. Good morning. All right. So you went over your rights with Mr. Bowditch?
Yes, Your
You
Honor.
understood those rights?
Yes, Your
You
Honor.
understand the options those rights give you?
Yes, Your Honor.
My understanding is that you are going to plead responsible to a civil infraction, double parking, and the prosecutor wants me to dismiss the ORV on a highway charge. Is that your understanding of the agreement?
Yes, Your Honor.
All right. Oh, actually, two charges. ORV on roadway and no valid operator's license. So both misdemeanors will be dismissed. That's the way you want to handle it?
Yes, Your Honor.
Okay. You've agreed to pay $175?
Yes, Your Honor.
All right. I'll send you downstairs so you can make a payment plan if you need to. What's the status of your license?
Invalid. I don't have one.
Okay. How old are you?
17. I plan to get my license when
Just
I'm
wait
18.
till you're 18?
Yeah.
Okay.
So I don't have to go through driver's training and all that.
So no driving?
No.
Okay. All right. Go downstairs and make arrangements on the money. Any
Okay,
questions?
thank you, Your Honor. No.
Okay. Yeah, you can take it down. Thanks. All right, you're all set. We'll walk the file down.
Have a good day.
You as well, sir.
Well, I didn't know if you were
Hope your
doing-
grandfather's feeling better.
Yeah, thank you.
No, there was another one with the
Do you understand, sir, that when you say no contest to me, in essence, what you're saying is, Judge, I'm not fighting these charges. You understand that?
Yes, sir.
All right. So I'm assuming one of you attorneys can give me the factual basis I need?
We'll stipulate to the police report.
All right. Well, I probably don't have a police report. Well,
Okay.
I've got an appearance ticket.
The defense will stipulate that the pig got out on 2 occasions and went across the street to the complainant's property.
Okay. Quiet, quiet, quiet.
And there's allegations that the pig did some damage.
And that's what the restitution hearing is going to be about.
That's what it would be about, yes.
Okay. All right. I'm satisfied with those facts. If you are, Mr. Parker.
I am, Your Honor.
Okay. What should I know before I set the terms of sentence?
Well, my client has had the pig for 7 years.
No, 8 going on 9.
Excuse me, 8 going on 9.
Is this like a farm pig or one of those
He's a
pot
mini pig.
bellies?
He's a mini pig, mini
Okay.
Giuliani.
Go ahead.
And these are the only 2 times that he has gotten out that we were aware of. There've been no complaints by any other neighbors. There's been no issues with him getting out since then. The one occurred in the spring when the ground around to the bottom of his pen was soft and he was able to push the bottom of the pen out. The second time is my client's mother accidentally let the pig out when she was going to clean something or whatever. And that's been it. Other than that, there's been no problem since then. As to the restitution hearing, Your Honor, this is involving alleged damage to a in-ground pond, the rubber liner, and probably won't be able to assess that until the weather clears up. And it can be
Well, at least get rid of the snow, right?
looked at. Yes, Your Honor.
It's coming.
Yeah. It's supposed to be 40 this week. Your victim's got her hand in the air.
It's all right. The other thing is that there are some unpaid medical expenses as a result of this particular incident also. So we will put all of that together and present it to the court. But I also give Mr. Barker the information that I have.
Okay. All right. Anything else as to sentencing? The restitution claim, I understand, we're going to deal with that later.
Yeah, yes, sure. Obviously, in terms of medical, we would need documentation of
Sure.
the cause of the medical issues.
Okay. All right. Anything else?
Thank you, Your Honor.
All right. Thank you. I'm assuming you have other animals too.
Was it?
I'm assuming you have other animals as
Yeah,
well?
yeah, we have 3 dogs.
Okay. This is the first animal issue at the location?
Yeah, I've never heard of
Well,
a large
the first
ticket.
2 animal issues.
Yeah, I've never had
No.
tickets for it.
All right. All right, I'll delay sentence on these 2 files, 6 months on each file. Stay out of trouble, no new violations. On each file, fines that cost $150. That money's due within 5 days. So we need to have it in 5 days, or we need to have a plan in place to get it. So go downstairs, either pay it or make arrangements to pay it. Anything else?
No, Your Honor.
All right, and I'll leave it to you 2 gentlemen to contact Heather to schedule restitution.
You're using the term gentleman very loosely.
Just have it. Just have it. Have a good day.
You do, Your Honor.
All right, Louis Abraham, come on up.
Ready, Your Honor.
For the record, Your Honor, Jeffrey Bowditch, on behalf of Mr. Abram, who is approaching. Sir, could you tell the judge your name for the record, please?
Louis Abraham.
Abraham, my apologies. Your Honor, today was an adjourned date on a compliance matter for
Right.
blight. We do have a path going forward. We do wish to get a review date after today. And Mr. Abraham and his family would invite the ordinance officer, Mr. Scott, to come and look at all the good things they've done.
Okay. Any chance this is not gonna resolve?
There's a chance that.
All right. Well, here's my problem. I've known the Abrahams for 30 years. Probably.
No, well, yeah.
Maybe more than
Yeah,
that.
yeah, more than that.
Yeah, longer than that, because you guys,
You need to reassign it, that's fine.
it's got to be reassigned if it's not gonna, I mean, if it resolves on a plea, I'm okay with that. But if it's gonna be a trial, I don't think I should hear it.
Well, I'm not convinced that there won't be a trial based on
Okay.
conversations I've had with them this morning.
Okay,
The court knows me, I resolve anything that's in front of me that has reasonableness attached to it.
Right.
So if that changes, and maybe with Mr. Bowditch's help, that may in fact occur. But I'm not there yet, pardon me, but I'm just not there yet. That's why I need a review date, a couple of months down the road, and I need Mr. Scott to have access to the property.
like 60 days? You want something
It's
in
fine.
late February? Into March?
March is fine, I don't mind.
Your Honor, and the Abrahams have approached the township and the police department. Now, I know Mr. Young isn't privy to what the Abrahams talked about, and there is a letter Mr. Abraham wants you to absorb if and when you have the time to do it, not today.
Okay,
But they do have a tentative agreement with the township. And again, Mr. Young's not involved in this yet, but to have everything done by
Right.
June. And all we're
Okay.
doing is asking Mr. Scott to come in.
and
make sure
I don't mind kicking it down the road on my docket, but if there's actually gonna be a trial, I'm not gonna have a trial with two guys I've known forever.
Well, Your Honor,
And consider to be friends. It's
I
not
think
just,
there's a great
acquaintances.
like resolve this.
all right. Well, I guess if we get to the point where we're not gonna resolve it, I can always kick it back. I
Yes,
mean, I don't think,
I think it'd be a good idea, it's where we're at in the first review date. That's why in March, we'll have a sense as to where we're at.
I mean, we're back in here on March 7th.
is Ron
I'm
scheduled
here
then?
March 7th.
No, you're not.
Oh.
No, you're not with us or till the end of the year.
No, but I'm saying ordinance item.
We only scheduled up to February. We gotta get together with new dates, more dates.
March 7th is fine with me.
I'll be in Florida.
Do we need you? I mean, at that point,
I'll be here.
I'm gonna assume at that point, either the township's gonna
It's
say
just a
we're happy.
review, right? It's not.
Oh,
Yeah, it's not a trial.
Okay.
Yeah.
Yeah.
Yeah, so either the township's gonna say we're golden, or the township's gonna say we're not, we'll give more time, or we're not, and we're done, wait. Right?
I mean, there's certain things that are
I
gonna be.
don't get into the details.
Yeah,
I'm just confirming we don't need Bill
no,
on the 7th of March.
No.
Agreed?
Agreed. One other matter, if I may, Your Honor,
What time are you doing it?
I did 9 a.m.
9 AM.
on the 7th.
Yep. Go ahead.
One other thing, Your Honor, it was brought to my attention today, first time that neither one of the gentlemen that are here today claim they own the property, that it's owned by their ex-wife and wife. And so I indicated that if that's the case, I can amend the complaint. Mr. Abraham indicated that he was the one that brought whatever it is that's on the property that we're arguing about.
That Mr. Abraham, Bill.
Yeah, everything's mine. So what we'll do is we, with that understanding, I'm not gonna amend the complaint to add the two wives at this point. And just take the responsibility of that which is.
Right.
Be a result of all of this.
Yeah.
Sir, could you tell the judge your name for the record, please?
Good morning.
You have to speak up a little bit, let know.
Darren Oakley.
Thank you, sir. Your Honor, today's a date and time set for hearing in this matter, I believe a pretrial. We waive formal reading of the charges and stand mute. We've had a chance to pre-try this case. In this matter, Mr. Walker is going to plead responsible to a double parking ticket with an assessed fine of $175.
Mr. Walker, is that your agreement?
Yes, sir.
Okay, I'll do that. You need some time to pay the 175?
Yes.
Go downstairs, front counter, set up a payment plan. Any questions? Is that a
Thank you, Your
no?
Honor.
Is that a no? No questions?
No, no, sir.
All right.
Thank you, Your Honor. Just go downstairs at the counter and ask them, tell them it's gonna take a few moments for the file to get down there. They'll answer all the questions.
How about Anita Walker?
Is she on her way in, sir? Pass this for just a second, Your
We
Honor.
can.
Then I have Miss Down.
Jamie Dowell.
Ready, Your Honor. Ms. Walker just rejected, but that's all right. Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and Ms. Dowell. Your Honor, I believe this is set for a show cause, but we would waive the formal reading of any arraignment stand mute. This is a truancy matter. I've spoken with the prosecution. I've spoken with Ms. Dowell. We have an executed plea agreement. She's going to plead guilty to the charge. With the understanding the matter will be taken under deferred status for a period of 12 months. She has, I believe, twin daughters, and one, because of the complexities of a multiple birth, is a little bit on the spectrum and has missed some days. But
How old are they?
Too many,
How old are they?
Oh, 15.
Okay. So one's got an attendance problem, one doesn't.
Yeah, one's
So-
autistic.
it's their second set of twins. But
Crazy.
uh,
Natural?
Yeah.
but they have turned the corner, and I also assured them that there would be another resource available at the court
Yeah.
if they'd ever be mindful to use it.
All girls?
Yes.
Oh, you poor thing.
Identical, and then my youngest.
How old's the other set?
23.
Oh, okay.
23 and
Then they're
15.
human again.
Yep.
Yeah.
Yes.
See, Judge, I told him he had a house full of pretty women, so, you know.
Well,
Yeah,
pretty or not, God bless you.
Yeah, he's definitely outnumbered. We give him a dog.
That's fun. All right. Okay, so you've gone over your rights with Mr. Bowditch.
Yes,
You understand your rights and the
Yes.
options those rights give you.
yes,
You understand the possible penalty for this charge.
yes,
All right. Understanding all of that, are you pleading guilty to the charge freely and voluntarily today?
yes,
Okay. Are you satisfied with the facts that you put on the record?
Yes, Your Honor, I'm sorry.
Are you satisfied that what he told me was true? It
Yes.
fits your situation?
yes.
Okay, all right. So this lady over here that's just kind of stalking is Christine Oswald. Let me give you her card. She's our juvenile probation officer here at the court.
Thank you.
She's the resource that Mr. Bowditch referenced. So if you're having any issues going forward, she's got all kinds of resources she can help you get in touch with.
Okay,
And sometimes you just need somebody to cry on the shoulder.
yes,
She's pretty good at that too.
yes.
Yeah.
Yeah,
All right, so you've already posted bond money on this. I'm gonna give you the money back, except we keep a 10% bond fee.
okay,
Yeah, thank you, Your Honor.
Oh,
Thank you.
and 12 months delayed sentence, as he explained it to you. So
Yes.
as long as we get to the next 12 months or through the 12 months with no problems,
yeah, they're not,
This goes away.
they're already improving and taking.
if it
things
looks
more
like you,
serious.
if it looks, what's your problem child, daughter?
Morgan,
Morgan. All right, so if it looks like Morgan's slipping into those bad behaviors again, reach out to her quick,
okay,
okay? Because the sooner she's involved, the more likely she's gonna be standing on the other side of you with Mr. Bowditch. If there's a problem, you gotta see me again
Right.
and say, Mom's been working with me. That's what
Right.
you want to say,
okay,
okay?
thank
Anything
you.
else?
Nope,
Good luck to you.
thank you.
Good luck to you.
I appreciate it.
Thank you, Your Honor.
Thank you, and
Ms. Walker, come on up. Mr. Bowditch, your appearance.
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of Ms. Walker, who's approaching. Ma'am, could you tell the judge your name?
Name is Neil Walker.
Good morning.
Your Honor, today's the date and time set for an arraignment in this matter. We waive formal reading and stand mute. We've also had a chance to pre-try this case. We do have an executed plea agreement in which Ms. Walker will be pleading responsible to double parking with an agreed upon assessed fine of $175.
I'm gonna do this on the beat ticket. Or you want to do it on this? These are civil.
Yeah.
Okay. All right, did you go over your rights and your options with Mr. Bowditch today?
Yes,
Did you understand all those?
yes,
Understanding all of those, are you pleading responsible to double parking?
Yes.
And have you agreed to pay fines and costs of $175?
Yes.
And do you need time to pay that?
Yes.
All right. I'll dismiss all the original charges. Send you downstairs to the front counter and make arrangements with them for the payment. Do you have any questions?
No questions.
You're all set.
Thank you, Your Honor.
You're welcome. You're welcome. You want it on the civil? The reason I didn't is because I don't, oh, I do have the civil here. Lost it.
Maybe it's her ashes, like, yeah, I saw that fact that he said that to me, I was like.
What do you say?
He said I had a cupcake with me, which was my cat that I had put down last week, and he's like, and I just didn't say anything, and he's like, her ashes, and I was like, oh, like, I was just like, oh my god, it was so creepy. They got it right to my house, but I was thinking, what about it? Yeah, that's how mine came, like, they.
The delivery kind of blows my mind.
Yeah, that's what I was saying, I didn't expect, I thought it was gonna come in the mail, they told me that it was gonna come to my house, and I thought it was gonna come in the mail. Right, but.
So what do? I deliver ashes.
In a car that even says, you know, the service, I don't remember, he had a minivan, I didn't, oh, because mine, it, like, on the side of it, or whatever.
All right, so they sent in a dismissal, nothing about the bond money that's on file. We can apply on a dismissal, we can apply bond to cost, can't we?
As long as you charge all the other things.
I don't think I can charge anything on a
Oh,
dismissal.
because it would have to say dismissed with cost, you're right. So. Just bond fee and cost, I guess?
Yeah.
Hello, I just did it. Is that in water? Yep, already done. Did you? Oh. Okay, thank you.
Sweet, Your Honor.
Yeah. How have you been?
I'm doing well. You look good.
Good. Yeah, everybody's healthy. Yeah,
I'm aging faster than you are, but then I had a head start, you know, so.
Because you're getting the stress. I don't get the stress. Yeah.
No, that's right. You get to give it now.
I give it now. Right. Tell me about this plea.
We've had a chance to pre-try this, and we've reached an agreement under which my client will plead no contest for civil liability purposes. The matter will be taken under advisement for 6 months with the condition that the pig not be allowed out, and that if there's to be restitution, that we're requesting a restitution hearing, and brother counsel has promised to provide us with all the discovery that is necessary in order to have the restitution hearing to determine what damage the pig actually did.
All right, so I've got 2 counts of animal at large. Am I taking a plea of no contest on both files?
We are, Your Honor.
Okay, all right, and both files will then be held under a 6-month delayed sentence.
Correct.
Okay, all right. So I'm assuming if the complainant contacts you, then you're going to contact Mr. Barker and we'll get something scheduled if we need
We
to.
can schedule it right now. I understand the 29th is the next time I'm before the court. If that,
I can't do the 29th.
all right, I will have to then, if it's all right, I'll go to Mr. Barker and we'll get together and we'll schedule it.
Does that work for you?
Yes, Your Honor.
Okay, all right. Mr. Harden, you've gone over your rights with Mr. Barker. You understand your rights and the options those rights give you.
Yes, sir.
All right. And you understand the possible penalty for these charges.
Yes, sir.
All right. Did you go over your rights with Mr. Bowditch?
Yes,
You understand those rights and the options those rights give you today?
yes,
You understand the possible penalty for the charge of assault and battery?
for the most part.
Okay, pretty simple. Up to $500 fines plus court costs and up to 93 days in jail.
Understood.
Okay. And you understand if you plead no contest, what you're saying to me is you're not fighting the charge against you.
Correct.
And if I find a factual basis that supports a guilty plea from that point forward, I'm going to go as if the file was a guilty plea, there'll be a sentencing. You understand all that?
Understood.
Understanding all of this, are you pleading no contest freely and voluntarily?
Yes, Your Honor.
All right. Let's see, do I have a police report? I do not. Somebody got a police report, or somebody want to put some facts on the record?
You want Mr. Bowders to put the facts on the record?
I don't care as long as somebody does.
You have a police report?
I have many police reports. Give me a moment, please.
Sure. Mr. Jones, do you have anything on your criminal history, misdemeanors or felonies? I'm not worried about traffic matters.
No.
You want me to put on the record the facts is,
I do think the police report supports a plea to assault and battery. And you both read the report.
Yes, Your Honor. Yes, Your Honor.
Would you agree?
no objection to the court taking that as a source of factual basis.
Thank you.
Defense is satisfied. Your Honor.
Any reason not to sentence immediately?
None that I can see.
What should I know?
Your Honor, I believe this is, as he indicated to you, this is a rush of this nature with the law. You're working, Mr.
Where do you work at, sir?
I work at Ford Motor Company.
How long have you been with Ford?
I'm sorry,
How long have you been with Ford?
8 years.
Go ahead.
Your Honor, he has a family, he has supported his family, they're with him today. That's about it, Your Honor.
All right.
This was a single incident, Your Honor.
Anything else you want me to know?
Nothing before, nothing since.
Thank you.
Me?
Yeah.
No.
All right. Do we have a list of names?
We do, Your Honor. Michael Bolick, B-O-L-I-C-K. James Alter, A-L-T-H-E-R-R.
I'm sorry, A-L-T-H.
A-L-T-H-E-R-R.
Thank you.
Diane Sloan, S-L-O-A-N.
Just the three.
Just the three.
Okay.
Your Honor, Mr. Jones, I have no problem abiding by the court's wishes.
Thank you.
Your Honor, just to make clear, we're requesting those three, their families, no contact in a period of 1 year.
Okay. Anything else?
Nothing, Your Honor.
Okay. All right, Mr. Jones, I'm going to go along with the recommendation for delayed sentence for 12 months. During that time period, stay out of trouble, no new criminal offenses, no contact with Michael Bolick, James Alter. How do you say it? Alter, or Diane Sloan. No contact. You see them at Burger King, you eat at Taco Bell. All right, these people don't exist.
Understood.
Don't no third party contact. If you have the means to do that, no phone call. Don't have anybody you know go see them. There's no contact.
Okay.
Court costs are assessed the amount of $500. That money is due within 5 days. That means we got to have it in our hand, or we got to have a plan to get it.
Okay.
So I'm going to send you downstairs right now. You can either pay it, make a payment on it, or set up a payment plan to get started on it. Any
Okay.
questions?
No questions.
Anything else?
Nothing, Your Honor.
Thank you.
Thank you, Your Honor.
Hey, Jamie.
Sure.
These are from Mackenzie. That's it.
We have another copy.
No, I'm mailing it.
Oh, he left.
Mr. King's not here.
Oh, I'll take it.
Mr. King's right here.
Said he left.
You want to shut this down, Heather?
Your testimony from Ms. Marquez Thompson was a domestic relationship with David for 6 months. And I have to prove that there was some phone fun. And then that violence happened on February 25th, 2024, at the Wayne County Airport. Or I'm sorry, yes, at the Wayne County Airport in Wayne County. And that it happened on or around. Now, You heard from Ms. Martinez. You heard how she came out from Naples. We saw a video where it shows her walking through the park. Then we heard how she saw the defendant's car parked by him. We saw a picture of the defendant driving around, and we saw Martina walk. Unfortunately, there's no video capturing actual. But we have the moments before, and we have the moments after. So we heard Martina testify that the defendant grabbed her right her collar and then hit her. But we do have pictures. We do have pictures of what the result might have. This is 30 minutes after what she got. What her living. The point of living. Her cover. Now, we heard that after this happened, she got to her car. We saw in the video the lights turned on. Then for a moment, we saw the lights here. And we saw both cars move both up the aisle. And we heard testimony from the detective or superintendent that the one vehicle stopped, the other vehicle stopped. And then we see Marquis Chevrolet wiggle past the defendant, in which we heard that both of these vehicles then exited one another. Now we heard from Miss Marquita Thompson that she was driving down I-94 at a speed to get pulled over to get help. She didn't call the cops because she was drunk. She didn't call until that night when she got home. She was sick. Now, we saw that later on, she goes to the police station the next day and telling after officers in Dearborn told her, hey, it's not here, have it on airport property, go there. She goes there. Now, I know there were some questions about where these pictures are. Now, as the judge instructed, these pictures are and the judge looked where the officer looked at the pictures. Captured this one, exactly. And saw her face when she came in, and she still had that. Now, ladies and gentlemen, people assert that that's fun. We met our verdict beyond a reasonable doubt. And now he asks you to use your reason that, as the judge will instruct you in a minute, that at the end of this, thank you all.
Mr. Starr.
Well, when I was in law school, from procedure, from a law professor told me to say, hey man, you have the concept of reasonable doubt. Look at things different. If I would have had reasonable doubt, that's saying if I had that concept down way back in the 90s, I would have told my friend Des, hey, play the next song. He wouldn't have been able to. I think there's things here where we can say, hey, play the next song. You're not able to. For example, the victim testified that she was parked in front of the defendant's car was behind him. Right? She's in front, he's behind. But yet when we see the video, we see lights come on. We see the car move forward. Whose car was it? You saw her car go the other way around. And that the gold Malibu pulled up in front. How was that possible? Can't back up, there's a car behind. Doesn't make sense. But then also too, we have some alleged evidence that's either missing or not here. The security video. They said there was more security video, but I developed. Time stamp. So I don't know. I was having. Show, okay, this photo was taken. This date, this time. You don't have that. Pictures of her face. When she made the police report. That's easily shown. You don't have it. What about this? What about proof that my client was calling her continuously and that she then blocked the number and then that my client supposedly called from other numbers? You got proof of that as well. That's not it. Now, going back to the point about I understand the different protocol. As we see, with this one, she's wearing a tank top. This one, she's not wearing a tank top. Which one was first? Which one was taken first? All right? These are her photos from her phone. It's not from tank top. Looks like a collar shirt. Right? So let me ask you this question. Then is that she was grabbed and punched in the face. Not sure what was in. Is this a bruise or a bump? Is it a bruise or a bump? A bruise. Yeah, you possibly could infer it. Someone possibly could have failed as well as other scenarios there, but a bump. See them. So there's reaction. No, it's a bump, it's not a bruise. I would suspect if someone punches you in the face, you're going to have a bruise. Not a bump on the lip. That's why I asked the question. Any other swelling? But instead we just have this bump right here. You're going to be able to watch the video in the future. You guys are going to go back there. You guys are going to break off about safe together. I want you to think about this question instead. Right? If you think about it, you play the next song. You can't play the next song. You got to come back. Okay?
Mr. Lecky.
So we did hear testimony about one of the things. Now, this one collared shirt. That same collared shirt she's wearing. So when she got home, she took this picture. She said 30 minutes after this one. Now this one. At about an hour. She changed her channels. Took pictures from different sides of the swelling. Now, we didn't hear testimony on this. We didn't hear testimony about where she's been. But we heard testimony about how this has been came to her place of work. Because couldn't get a hold of her any other way. Trying to get in touch. Just trying to get. And when she went compliant, when she told him she's not his anymore, he punched her. Now, I'm gonna ask you again. That based on that, that you find this defendant guilty. Be honest. Yes.
Thank you, gentlemen. All right, folks, time for more criminal jury instructions. These are your final instructions. The evidence and arguments in this case are finished. I will now instruct you on the law. That is, I will explain the law that applies to this case. These are under final instructions. If you want to follow along, I'll give you a chance to get there. Ms. Vanderfleck, you having trouble? Okay. All right.
Is that the one that says the elements of the crimes?
Not yet. Starting with final instructions, bold print at the top, and right under that page 1, duties of judge and jury. We're good? All right. Paragraph 2, remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that. A doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answer. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I may have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things into judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court officer. It is not proper for you to talk directly with the judge, lawyers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been omitted, ask for them. When you go to the jury room, you will be given an electronic copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. The attorneys and I have all approved a jury verdict form that will go in with you to the jury room as well. Now, if you flip back to the little blue index, I'm going to evidence instructions. Thank you. Page 1, circumstantial evidence. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. If you believe that a witness previously made a statement inconsistent with their testimony at this trial, the only purpose for which that earlier statement can be considered by you is in deciding whether the witness testified truthfully in court. The earlier statement is not evidence that what the witness said earlier is true. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. Back to the index page, folks, for witness instructions. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proved beyond a reasonable doubt that the defendant is guilty. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witnesses. Gentlemen, are you satisfied with the instructions as given? Thank you, gentlemen. All right, folks, this is my least favorite part of a jury. If you can count, you see there's 7 of you. And I've said a couple times it's 6, 6, 6, 6. So that means one of you get kicked off. And the reason I hate that so much is I've been watching. You guys have all been engaged. I mean, I didn't, Mr. Sharp wasn't sleeping, so I want to kick him off. Everybody was listening and engaged. And I mean, you asked great questions. So I've got 7 little beads in this little box, and they've each got a number on it. One of them is going to be yours. Juror number 6, Ms. Vanderklee. So here's what I'm going to do. You don't get to go in and deliberate. I'm going to send these guys in to do it without you. It'll probably take twice as long without a woman in the room. That's probably true. But what I'm going to do is I'm going to encourage you to stick around. You don't have to. I'll release you officially right now. But I'm going to encourage you to stick around because when we're done, when they've given their verdict, when I've shared that with the courtroom, I'm going to go back in there and I do what I call my debrief. You're invited back for that. And I'm also going to ask each of you if you'd be willing to stick around and give some feedback to the attorneys if they want it. Because I've done this with every one of my jury trials since I got on the bench in 1999, and I can't tell you how many times I wish I would have had the chance to do this with my jury trials that I did as an attorney and get some actual feedback. I think it can be very, very effective feedback for a trial attorney to listen to what you folks are thinking after you watch him in action. All right. So with that lecture, you can leave. The rest of you, you might as well all get up because now Joe's going to take you back in and make you work. This is the time to take your notepads, your tablets. Yeah, questions?
Yeah. What are the charges again? Is it just one?
Just one charge, the charge of domestic violence. Yep. So take your tablets if you want them, take your notepads if you want them, your waters, whatever you want to take back there with you. If you forgot something, we can get it later.
You allowed to have the photos?
Yeah, you can take those back right now. Mr. Lecky, you got them? If you want to see the video again, we'll bring it back out here and play it out here on the big screen and the little ones in front of it. Right. You can just have a seat. Yeah. Yeah.
Are you breaking for lunch?
I don't think you're breaking for lunch. No, they just want to work.
At first glance, this moment inside the courtroom seems routine, but every choice made here carries real weight. One after another, individuals approached. Some were dealing with minor offenses like traffic tickets or small violations. Others stood there facing far more serious issues. And time after time, the judge offered alternatives, plea agreements, lowered charges, structured payments, even opportunities to avoid heavier outcomes. But every agreement had a catch. Obey the conditions, or the consequences return. In one instance, a young defendant took responsibility and managed to escape more severe charges, but received a strict warning not to drive again without a valid license. In another case, someone agreed to a delayed sentence, meaning if they remained trouble-free, their record could remain untouched. Still, the judge emphasized one critical point: no contact orders, firm deadlines, and absolutely no tolerance for breaking the rules. Because even a minor offense can quickly escalate if ignored. This wasn't just about handing out punishment. It was about offering an opportunity while ensuring it isn't wasted.